in a moment. It is a principle of diplomacy that one must know something of the truth to lie conveniently. And if you also abide by the same, you have come to the right place. So, hello and welcome. This is Himanshu Kaushik, your host of the day, and I would like to welcome you all in today's webinar on United Nations and modes of settlement of international disputes. And I hope that you all are doing fine, safe, and happy at wherever you're taking this webinar from. So before we move on and learn a lot more about the nations and the disputes and international policies through our session today, we have our expert with us. So I shall introduce you to our expert. We have Dr. Sanjay Pasi sir, Professor, School of Law, Lovely Professional University with us here. He is a magnetic personality with over 15 years of teaching and research experience to his credit. He has worked as Dean and Professor at Jagannath University, Haryana, and as HOD at Gita Institute of Law and other experiences as well. He has his qualifications from Kurukshetra University with UGC NET qualified already. He also has attended several webinars and conferences and has been convener and an organizing manager or member of various national and international level seminars and moot courts. His expertise is in constitutional law, criminal law, and international law as well. Sir, it is a pleasure for us to be here and looking forward for an amazing session, sir.
Thank you, ma'am. At the outset, I welcome all of you in this webinar on behalf of School of Law, Lovely Professional University. Today's our topic is United Nations and modes of settlement of international disputes. But first of all, we will discuss about is there any law, is there any need of law at national level or not? Why we have required the laws? We have required the laws. The reason is behind of that we want the peace and prosperity. Without law, the peace and prosperity, that is not a possible. So that's why the law is required. As you know that we got independence in 1947, and already we have the constitution, the supreme law of the country, the law constitution. And the constitution, there are the three organs. First is the legislature, second is the executive, and the third one is the judiciary. And it is the duty of the legislature to enact the laws. It is the duty of the executive to execute the laws. And the third one is the judiciary, and it is the duty of the judiciary to enforce the laws. It means that we have a mechanism to enact the laws, to execute the laws, and to enforce the laws. So we have a mechanism, and whatever the law the legislature is enacting that are bound with us. It means that we cannot deny if we are not bound by that. It means that if suppose if we will commit any crimes, then in that case we are subject to the punishment. As you already know that if suppose there is any rules, if suppose we will commit any theft, say if we will break the traffic rules, then in that case we are subject to the punishment. Then it means that there is a system. There is a system, there is a mechanism to enact the laws, to execute the laws, and to enforce the laws. And that is required to maintain the law and order in the country, because without law and order, you cannot accept the prosperity. Without the law, you cannot accept the prosperity of the people's hearts. So at the national level, we have required the laws. Similarly, now the question arises that international, why the international law is required? Why the international is required? Is there any international matters? That's why the international law is required. Definitely, there are so many international matters that cannot be resolved unless there is a law regarding that, unless there is a body regarding that, unless there is a body to enforce that. So at international levels, there is a at the international levels, there are so many issues. For example, the environment pollution, because the environment pollution that is not limited to any country. That problem we can resolve through international cooperation only. Similarly, the terrorism, that is not only the problem for only in India, that is a problem for every country. Similarly, there are so many other issues there, and the main issues about the international peace and security. Without the international peace and security, neither any state can accept the prosperity. It means that neither any state can develop itself. So there are so many issues that is resolved can only by the international laws. And the prosperity, what we expect, that is only possible when there is an international peace at the international levels. But now the question is that at the international level, is there any mechanism similar to the law of nations? In every country, there is a system, there is a mechanism to execute the laws, to enact the laws, to enforce the laws. But international level, is there any body to enact the laws, to execute the law, or to enforce the laws? As you already know that already we know about the First World War and the Second World War. It means in the past, there are the two World War in which every states have participated. Or as you already know that what is the result? What is the result of the war? Ultimate, there is a destruction. Ultimate is the loss of the human beings. So that's why after the First World War, League of Nations that was established, and the main purpose at that time of the League of Nations was to prevent the Second World War. But unfortunately, that organization that was failed to prevent the Second World War. And after the Second World War, there are so many powerful states that have started efforts for the another international organization. And finally, the United Nations came into existence in 1945, 24 October 1945. And the main purpose of the United Nations is to prevent the Third World War, because we know that what are the effects of the war. So that is the big achievement of the United Nations till yet. In the history, there is no Third World War. In history, there is no Third World War. It means that is a big success. But sometimes the United Nations that is criticized due to some reasons. The reason is that sometimes the United Nations are not able to take action regarding certain important matters. So that's why there are so many failures of the United Nations also, but we cannot deny the importance of the United Nations, because at present there are the 193 states that are the member of the United Nations. That it means that is the international bodies, that is the international organization where we can discuss so many important matters. So we cannot deny the importance of the United Nations. The United Nations, in the United Nations, there are United Nations that have based on the UN Charter. And the UN Charter, there are a lot of rules under the UN Charter. In the beginning, we will see first about the preamble of the UN Charter. In the preamble of the UN Charter, that is specifically mentioned that we, the people of the United Nations, are determined to save succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reform faith in fundamental human rights, in the dignity and worth of human person, in the equal right of men and women, and of nation large and small, and to establish conditions under which justice and respect for the obligation arises from treaties and other sources of international law can be maintained, and to promote social progress and better standard of life in the large freedom. And for this end, to practice tolerance and live together in peace with one another as one neighbor, and to unite our strength to maintain international peace and security, and to ensure by the acceptance of principles and the instructions of method that armed force shall not be used, save in the common interest, and employ international machinery for the promotion of the economic and social advancement of all people. So as you can see in the preamble of the United Nations, that is specifically mentions that ultimate purpose of the United Nations to protect the succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind. So as already we have discussed that the result of the war, that is not a good for any person, or that is not a good for any countries. In the preamble of the United Nations, that is specifically emphasized on the equal rights of the men and women and of nation large and small. Whether it is a man, whether it is a woman, that are equal before the laws, and whether any nation, whether it is a large or whether it is small, whether it is a developed or whether it is a developing country, all are same in the eyes of law. In the preamble of the United Nations, specifically emphasis is given on the peace, to maintain the peace. To maintain the peace. Even in the next slide also, that is specifically mentioned that whether it is a small country, whether it is a powerful country, we have to live together in peace with one another as a good neighbors to maintain international peace and security. We have not to use the armed forces. So under the preamble of the UN Charter, that is specifically mentions about to live with the peace, means that every nation that will not use the armed forces, that will whatever the dispute that will be arise, that will resolve through the peaceful manner. Even the Sabah Qureshi is the 77th president of the United Nations General Assembly. What he stated when he becomes the president of the General Assembly, what he stated in their lecture, the United Nations was created out of the ashes of war and destruction with the intention of being a well of solution. So it is specifically mentions that was created out of the ashes of war. We know that before that there was 2 world war, and we know what are the consequences of the war, what are the results of the war. And the new president added that the risk of the use of nuclear weapon is now higher than the past 14 years. So you just imagine that the nuclear weapons, that is not only the harmful for our country, that is harmful the entire world. It means there are the certain restrictions that we have imposed through the United Nations, through the international treaties. State those who have the nuclear weapon, they will not use. But in spite of that, who was the president of the United Nations General Assembly that have in their statement that have added that the risk of the use of nuclear weapon is now higher than in the past 40 years. So you just imagine that what is the situation in the entire world at this time. It means what he want to tell us that. It means that maybe there is a possibility, maybe in future the Third World War is a possible. Maybe in the future there is a use of the nuclear weapon is a possible. If you will see the provision of the UN Charter that specifically mentioned, even Article 2 Clause 3, if at the international level, if any dispute arise between the nation, so it is the duty of every nations to resolve the dispute by the peaceful means. So as you know that if we will not use the force, then in that case, if we will not use the force, then in that case, a peace and perspective will be remain intact. If any dispute is arising, what is our duty as per the UN? We will resolve that disputes by the peaceful manner. So there are so many peaceful methods under the international law to resolve the dispute that we will discuss in the coming slides also. Even Article 102 Clause 4, it specifically mentioned that all member states who are the member of the United Nations that shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. That is specifically mentioned that any state who are the member of the United Nations that cannot use the force against any other state. It means that that will give respect to the territorial integrity or political independence of the other state. So in the UN Charter, whatever the UN Charter on the basis of the UN is based in that specifically, that are focusing only on the one point to maintain international peace and security. If any dispute will arise between the states, that will resolved by the peaceful means. And whether you are powerful state or whether that is a weak state, you will not see you will not interfere in the internal matters of the other states. So as you already know that there are 6 organs of the United Nations. First is the General Assembly, and the second one is the Security Council. Third one is the International Court of Justice, and fourth one is the Economic and Social Council. Fifth one is the Secretariat, and sixth is the Trusteeship Council. General Assembly, that is one of the most democratically represented organ of the United Nations. And all members of the United Nations, it means the 193 members that are represented under the General Assembly. But question arises sometimes, what is the value of the resolution passed by the General Assembly? So there is no legal value of the resolution passed by the General Assembly that are only the recommendatory in nature. Then about the Security Council. Under the UN Charter, it is only the Security Council to whom the responsibility to maintain international peace and security is given by all the states. Security, it is the duty of the Security Council to maintain the international peace and security. Under the Security Council, there are 15 members, and 5 out of 15 members, 5 are the permanent members. 5 members that are, first is the USA, and then another is UK, then France, then Russia, and then China. These are the 5 members, and these 5 members that possess the veto powers. So it means ultimate at the international level, Security Council that is responsible to maintain international peace and security. It means that if any matters relating to the international peace, if any action is taken against any state who is disturbing the international peace and security, who threat to the international peace and security, then who will take that action? That is only the Security Council. Security Council. It means that the 15 members that have power regarding of that. Out of, but in the Security Council, if the Security Council have to take any action regarding of any state regarding to maintain maintain international peace and security, then it is required that those who are the 5 permanent members that give their votes. Agar if suppose any member out of 5 members that give no vote, that abstain itself, then in that case the Security Council cannot take a decision. Recently, in the war between the Ukraine and Russia, as you already know that the Russia that is also the first that is also the permanent member of the Security Council. So at the initial stage, we have discussed that due to so many reasons, the United Nations that was criticized, and one of the reason that is the veto power possessed by the Security Council, 5 permanent by the 5 permanent members of the Security Council, and that is the reason where there is an exclusive interest of these 5 permanent members. In that cases, they are failed to take decision. It means that in the Ukraine and Russia war, we cannot take a decision because in that the Russia have used their veto power. It means that the Security Council cannot decide, cannot take an action against the Russia because already the Russia is the member of the permanent member of the Security Council, and without their vote, it is not possible. So at the international levels, all the members have given the responsibility to the Security Councils to maintain international peace and security. And whatever the Security Council decision that will be taken, that is accepted by all the members. But the veto power, that is a weakness of the Security Council. Due to that reason, Security Council that is not able to take action due to certain reasons. Similarly, the International Court of Justice. Already at the beginning of the lecture, we have discussed about there is a need of the judicial mechanism to enforce the laws. So under the international, there is also at the international, there is the International Court of Justice. But in the International Court of Justice, there are the 15 judges that are elected for 9 years. But what is the weakness of the International Court of Justice is that the jurisdiction of the ICJ, that is not a compulsory. It means that unless and until we will hand over the matters to the ICJ cannot decide that. So, but in our country, the system is totally different. In our country, whatever the judicial mechanism, we are bound by that. It means that what the courts will give the punishment, we are bound by that. It means that we cannot deny. Suppose in any case, our courts, the apex court, the high court, the district court, if suppose that is giving the punishment of 2 years, 3 years, 10 years, then in that case, whatever the judgment that is giving, that is bound by us. It means that we cannot deny that. But at the International Court of Justice, that cannot decide any matter unless and until we hand over, we entrust that matters to the ICJ. So that is the main issue. It means that the jurisdiction of the ICJ is not bound. Another is the Economic and Social Council. That is also one of the important organ of the United Nations that also works for the General Assembly, Security Council, or that is a great platform for international dialogue between the policymaker, between the academicians, and between so many other or international organizations. Similar to the there is the secretariat that also work for the General Assembly, Security Council. Similar the trusteeship council that is not in existence now. So there are the 6 organs and that are playing their own role. But out of the 6 organs, the main organ that is the Security Council, whose main responsibility is to maintain international peace and security. Whose main responsibility is that if any state that violates international peace and security, that will take action against that state. So there are specifically there are the main 4 purposes of the United Nations. First is to maintain international peace and security. Second is to develop friendly relation among nations, and the third one is to achieve international cooperation in solving international problems on economic, social, cultural, or humanitarian character. Then to make the United Nations a center for the attainment of above common ends. There are the 4 main purposes of the United Nations. But out of these 4 main purposes, the main purpose of the United Nations to maintain international peace and security. That is the main purpose. Or that is not only for those who are the member of the United Nations that will only maintain the peace and security. That is for every nation, whether you are a member of the United Nations or not. That is for every member that will maintain the international peace. So already we have discussed that those who are the member of the United Nations that have conferred upon the Security Council the primary responsibility for the maintenance of international peace and security. And the member have also agreed that in carrying out duty, the Security Council act on their behalf. And the member of the UN have also agreed to accept and carry out the decision of the Security Council with the least diversions for the armaments and the worst human and economic risks. So it is very clear that at the international level, there is a body to maintain international peace and security, that is the Security Council, or at present 193 states that are the member of the United Nations, and all members that have conferred these powers to the Security Council that is empowered on their behalf to maintain the international peace and security. And it is accepted to all the nations, those who are the member of the United Nations. And pacific means of settlement, I have already discussed that our topic is United Nations and mode of settlement of international disputes. And under the UN Charter, Article 33, para 1 of the Charter, that provides that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliations, arbitration, judicial settlement, resort to regional agencies or arrangement or other peaceful means of their own choice. It means that under the UN Charter, that is specifically mentioned that you will resolve if any dispute will be arise between states, and that will which is likely to endanger the maintenance of international peace and security. Then first of all, that will resolve that dispute by the peaceful means. Even not under the UN Charter, even under the law of the Constitution, you can say the Constitution of India, Article 51, that also specifically provides that the state shall endeavor to encourage settlement of international dispute by the arbitration. So even our Constitution that also emphasizes that the state shall endeavor to encourage settlement of international dispute by the arbitration. It means that if any dispute will be arise, so that can be also resolved by the arbitration. That is not at the international level, even at the national level also. So first mode we will discuss about the arbitration, that is arbitration. So what is the arbitration, first of all? Arbitration is one of the way to resolve the dispute between the states by the peaceful. Arbitration is not only the way at the international to resolve the dispute by the peaceful And these arbitrators are selected by the party. They are selected or appointed on the basis of consent of the party to a dispute. Their decision or award is binding upon the party. Arbitration that generally that is appointed with the on the consents of the part. It means that arbitrator that will appoint either that will appoint one, that either that will appoint three, either that will appoint five. It means that that will be appointed in a odd number. It means that if suppose if in regarding of any dispute, if arbitrator is going to be appointed. So if suppose one arbiter is going to be appointed, so it means that one arbiter that is appointed with the consent of the both state. If suppose there are the three arbitrators in are appointing to resolve any dispute, then in that case, one arbitrator is by the consent of one state, another arbiter is consented by the another state, and the third one is appointed by the consent of both states. It means that in the arbitration, arbitrator that is choosing by the party themselves. It means whatever there are decisions that are binding by the parties, it means that there is no appeal against the arbitral award. It means that is binding by the party. It means the party cannot deny to accept that awards. Hague Convention of 1899, that is a major convention relating to the codification of the arbitrations law. Similarly, the another important result of the Hague Conference of 1899 was the establishment of the permanent court of arbitration. And this work was completed by the Hague Conference of 1907. So already you can see there is a law relating to the Hague Convention. There is a permanent court of arbitration regarding of that. There is a one dispute with Alabama Claims Arbitration 1872. During the Civil War, Britain was neutral, but Britain provided the facilities to the southern states for the fitting and construction, etc. of Alabama and other destroyed its territory. In this case, America had claimed compensation for Britain on the ground that it had violated the law of neutrality. The arbitrator gave their awards in favor of America and held that Britain should pay 1.55 crore in compensation. As remarked by Judge Hudson, the success of Alabama claim arbitration stimulated a remarkable activity in the field of international law decision. So Alabama claims arbitration. It means dispute arises between the USA and Britain because during the Civil War in America, Britain that have violated the neutrality, that have provided facility to the southern state for the constructions of for the fitting and construction of the Alabama and some other destroyed. In that case, the America have claimed that the Britain have violated their neutrality, and that's why finally that have agreed to resolve their dispute by the arbitrator, and the arbitrator that have given their decision in favor of USA. And finally, the Britain have given the compensation to the USA in that is $1.55 lakh in compensation. So that is a remarkable. It means that without using force, both states have resolved their dispute. Then there is another one, that is the Kutch Arbitration Awards. That is a dispute between India and Pakistan about the 300-500 square miles of the lands. Run of Kutch is a place on the border of Gujarat and West Pakistan. There was a dispute between India and Pakistan in regard to some land in the Run of Kutch. Pakistan that claimed 3,500 square miles of the said land. This led to the armed conflict between the two countries in 1965. After the ceasefire, both India and Pakistan agreed to refer this matter to arbitrations. One arbitrator, L.S. Weber of Yugoslavia, was nominated by India. The other arbitrations, Nasrullah Intijam of Iran, was nominated by Pakistan. And the third was to nominate with the mutual agreement of both the states. Already we have discussed that if arbiter that can be appointed 1 or 3 or 5. In that case, there are the 3 arbitrators, and the one in that case that appointed by the India, and the another that appointed by the Pakistan, and the third one that is nominated with the mutual agreement of both the states. Since India and Pakistan could not agree upon a third arbitrator on the request of both the country, Judge Gunnar Lagrange, the chairman of the arbitral court, was nominated by the Secretary General of the United Nations. It means the third arbitrator, there was not a common consensus regarding the third arbitrator, and finally third arbitrator that was appointed by the with the consent of the both states. In that case, the arbitral court that keep its award on 19th Feb 1968, and according to the award, it 120 square miles, about 10% of the Pakistan claims of the land belong to Pakistan and the rest belong to India. It is one of the well-recognized principle of international law that the award of international arbiter is binding upon the party, and consequently, India accepted and implemented. So it is very clear that if any dispute arises that can be resolved by the peace, it means that those arbitrators you are appointing that are impartial, that are not favoring one nation or the other nation, that resolving the disputes about the facts on the basis of the merits, and that decision is binding by. So it means that at the international levels, no need of the use of the force if the dispute can be resolved by the peaceful. So arbitrator, that is one of the more to settle the international dispute by the peaceful. Then the another way, there are so many advantages of the arbitration. Arbitral procedure is more appropriate than the judicial settlement for technical dispute. So as you know that if you talk about the judiciary, we talk about the judicial mechanism, there are so many technicalities. Another, that is a less expensive. Then after that, the arbitrator can be conducted without publicity, even to the extent that party can agree that the award be not published. Then award is a bind. So there are so many advantages of the arbitration. There are so many advantages of the arbitration. Similarly, with the advantage, there are some disadvantages. First is no appeal. The arbitral decision is final. And the another is the cost. While arbitration is generally a more cost-efficient legal settlement option, it might not take sense in cases with a minimum money. So in those cases where the dispute is about not about the lot of damages, then in that case the way of the arbitration is not an active date, because the cost of the arbitration that is very high. Then the another mode, that is the negotiation. Negotiation, that is also one of the way to resolve the disputes. So as you already know that if any dispute that arises at and daily routine in our life also, that we can resolve also by the negotiation. Similarly, at the international levels, the negotiation, that is also one of the way to resolve the dispute. So who can negotiate? Generally negotiate, that can be by the head of the states, who is the head of the state, or by their accredited representatives, or by diplomatic agents. So it means that for a negotiations, a state can give an authority to any their representatives or any their diplomatic agents that can do negotiate on behalf of their own states. In those cases where the negotiations are carried on by big state on the one hand and by the small state on the other hand, we have to say when the party are unequal, it is likely that the small power may be subject to the will of them. So that is in the case of the negotiation, that is a possible. If any dispute that arises between a powerful state and between a weak state, then in that case, maybe who is the powerful state that will dominate during negotiations to the small state. The possibility of imposing influence by the big power of its counterpart is greater in negotiations. So that is the weakness of the negotiation. There are so many instances in that where the party have resolved their dispute by the negotiation. In 1976, India and Pakistan settled their outstanding differences in the Shimla Conference. Similarly, in 1974, India and Sri Lanka settled their boundary dispute by negotiation. In 1977, the Farakka barrage issues were also settled through negotiation between India and Bangladesh. So there are so many instances, even the India have resolved the dispute by the negotiation. It means that issues arising between these countries and that have not used the force, and finally that have resolved their dispute by the negotiation. The success of the negotiation as a dispute resolution is reflected in a dispute between Iran and US. So there is also one example, and there is a dispute arising between the Iran and US. The fact involved was that an Iranian airliner was shot down on July 3, 1988 by a missile fired from an American cruiser that killed 290 people. And the USA termed the incident as an accidental, but Iran filed the claim including compensation before the ICJ, to which the US objected. And finally, both states in the last that agreed to resolve their dispute by the negotiation. And in that case, US agreed to pay $131.8 million to Iran as settlement of Iranian claims, including compensation to the people killed in the incident. So this shows how a big power can also bow down to a small power if good tactics are used during negotiation, and reverse the true power negotiation. Undoubtedly, a big state that can dominates to the small state, but we cannot deny the importance of the negotiation, because if you can resolve any dispute by the negotiation, that is a good tool for the international peace and security. It means that if you are using that way to resolve the dispute, it means that you are not using any force, or ultimately you are protecting the human beings. As you already know that the result of war, the result of war is the destruction. The result of war is loss to the human beings. So that is also after the arbitration, you can also take the help of the arbitration to resolve dispute at international level. Similarly, you can take the help of the negotiation to resolve the dispute at international levels. There is also one example. There is also another example of the United States of America and Iran, and that have also resolved dispute by the negotiation. In that case, who is the president of the Iran, Hassan Rouhani, that insisted that their country had the right to enrich uranium, and therefore the nuclear problem cannot be solved. And finally, due to that reason, the issues arise between the America and the Iran and some other countries. And finally, that have resolved their dispute by the negotiation. And ultimately, it was negotiated and agreed that Iran did not have a right to increase the uranium, but Iran could continue to do so at a very low level, to which Iran had agreed, and the matter had come to an end. So there are so many instances that we have seen. You can resolve dispute by the peaceful means. First is the arbitration, and then there is the negotiation. Then third one is the good offices. So that is another way to settle the international disputes. The good offices, when two states are not able to resolve their dispute by a negotiation, a third state may offer its good offices for the same. These offices may also be offered by international organizations. Third state or international organization creates such an environment as may be conductive for the settlement of the disputes. Some general suggestion may also be put forward, but the third party does not take active part in the negotiations. So in the good offices, a third state, or you can say an international organization, that are offering the good offices, that are offering their services, that are creating an environment to resolve the dispute between two states. It means that in the good offices, the third state is not taking actively participate, just that only offering their services, that creating an environment to resolve the dispute. It means that that not creating any that are not actually participating to resolve the disputes. There are an example of the good offices also. Good office is a procedure whereby the third party brings the conflicting party together without participating in the negotiation. Prime Minister of United Kingdom, Mr. Wilson, provided good offices to India and Pakistan, which resulted the party to reach an agreement to refer Kutch issue to arbitral tribunal. Already we have seen that. Already we have discussed about the run of the Kutch case, and that is only the Prime Minister of the United Kingdom, Mr. Wilson, who provided their good offices to India and Pakistan. Finally, these two countries that have agreed to resolve this dispute by the arbiter. So it means that the good offices, that is also one of the way that create an environment, conductive environment to so there are so many examples also. McNaughton in 1949, Dixon in 1950, Graham in 1951, and Jennings in 1957 were appointed by the Security Council as a United Nation representative to settle the Kashmir dispute between India and Pakistan. So there are so many examples of the good offices to resolve the dispute at an international level. Now, the another mode to settle the international dispute, that is the mediation. Mediation is yet another method through which efforts are made to settlement of international dispute. In the case of mediation, the third state or individual not only offer its services but actively participate in the talk to the resolve the dispute. In the good offices and mediation, that is the main difference. In the good offices, we just only creating an environment. We are not actually participating. It means the third state, or you can say the international organization that will not actually participate, just that creating an environment to resolve the dispute. But in the mediations, you actually participate to resolve the dispute. So there is also an example of the mediations. Where is the mediation? The conflicting parties submit their dispute to a third party who facilitates the negotiation process and actually participate in the negotiation to form the terms of settlements. Soviet Union President Kosin mediated in the dispute between India and Pakistan, which resulted in the conclusion of Tashkent Agreement in 1966. So there is an example. So in that case, the mediation, you hand over the dispute to the third party actually participate to resolve the dispute. And there is an example of the Tashkent Agreement between the India and Pakistan. What is the another question? What is the difference between arbitration and mediation? So you can see the difference. The arbitrator that does an act of the adjudicator. The mediator work as a facilitator. It means that if arbitrator that is giving any judgment, that in that case, that judgment that judgment, you can say that awards that are binding. But in the mediation, that work as only in the facilitator. The award given in an arbitration proceeding is binding on the parties, and a settlement is binding only when it is mutually agreed upon by the both parties. So in the arbitration, whatever the awards is given by the arbitrator that are binding, but at the international levels, if the mediator that is resolving the disputes, then in that case, if that is not the party is not agreed, then in that case that is not a binding. An arbitration party do not communicate with each other, but in the mediation parties communicate with each other in the presence of mediator. Arbitrator, that is an expensive process, but the mediation, that is an economical process. So that is the main difference between the arbitration and the mediations. Conciliation, that is also another way to resolve the disputes. In the conciliations, matter is referred to a commission or committee which submit its report and recommend certain measures for the settlement of dispute, and proposal are however not binding upon the party. In the Professor Ojja's person, conciliation is a process of formal proposal of settlement after investigation of the facts and an efforts to reconcile, to accept or reject proposal formulated. So in the conciliation, a commission is appointed that finally investigate the matters, that will lay down the reports. If that is accepted to the party, it's okay. If that is not accepted to the party, then it's also. It means whatever the way we have discussed till now, only in the case of the arbitration, if arbitration that is giving the award, that is only binding by the party. In the other cases, unless and until the both parties are agrees, the whatever the decision have been taken regarding that are not bound by the party unless and until the both parties are. In 1952, the Belgo-Danish Commission and the 1956 and the Greco-Italian Conciliation Commission were the key example of the appointment of a Conciliation Commission for the settlement of dispute with reference to international. Similarly, there is also one of the another way, that is the inquiry, but that is not the independent method to resolve the international disputes at international levels. That way that is used to that way that is used with the another method to resolve the international disputes. So already we have discussed these are the ways. One way is also that is the ICJ. You can say that is the judicial settlement. It means that if both parties, suppose any dispute arises between the party and suppose that are agreed to resolve their dispute by the peaceful means, then that can hand over that matters to the ICJ, and ICJ can give the decision in that case. And the judgment of the ICJ that is binding by the parties means that after that, if ICJ is giving any decision, then regarding of any matter that is voluntarily handed over by the party, then after that, that parties cannot deny that. If suppose one party denied to follow that decision, then in that case, another party can approach to the International Security Council to enforce that decision. So these are the peaceful way to resolve the international dispute at international levels. And we have enough time. Yeah, we have to.
No, sir, we have enough time, sir. You can carry on, sir.
Okay, fine. So another way, whatever the way we have discussed, that are the peaceful way to settle the international dispute. Another is a compulsive means to settle the international dispute. These are the retortion, the reprisal, intervention, passive blockade, and the embargo. These are the compulsive way to settle the international dispute. The first way, that is the retortion. When a state behave in a discourteous manner with another state, then the international law confer right upon the state affected to resort to retortions. The word retortion means the retaliation, but the affected state can take only those means or measures as retortion which are otherwise also permitted under international. In retortion, the retortion, that is the compulsive mean. How that is a compulsive? When any state that not follow the international law, or when any state that will behave in a discourteous manner, then in that case we can take recourse of such methods. It means that in that cases we can whatever the diplomatic relations we have with another country, with that country we can end that relation. We can whatever the privileges we have given to the diplomatic agents of that country, we can withdraw also. And whatever the economic facility we have given, that may be stopped. In this present period, you can see during the Ukraine and Russia war, there are so many economic sanctions that have been imposed by the other states. There are so many economic sanctions. You can see all these economic sanctions. I have already mentioned about that. These economic sanctions that are fossil fuels. On 28 Feb 2022, Canada banned imports of Russian crude oil. Similarly, on March 8, 2022, US President John F. Kennedy ordered a ban on imports of oil, gas, and coal from Russia to the United States. In May 2022, the European communities proposed a ban on oil imports from Russia. So these are the economic sanctions that are imposed against the Russia by the other states. Similarly, in a 22 Feb 2022 speech, US President John Biden announced a restriction against 4 Russian banks, including as well as on corrupt billionaires close to Putin. Similarly, the UK Prime Minister's Boris Johnson that announced that all major Russian banks would have their assets frozen and be excluded from the UK financial system, and that some export license to Russia would be suspended. He also introduced a deposit limit for Russian citizens in UK bank accounts and for the assets of the over 100 additional individual and entities. Similarly, the major multinational companies, similarly the aviation. So there are so many economic sanctions that have been imposed during the Ukraine and Russia. It means that if any states that not following international law, then in that case, we can impose economic sanctions against that state. We can separate our economic relations with that states. We can, and the diplomatic relation with that states. So there are under the retortion through retortions, you can compel the other states to follow the international law. That is the compulsory means to resolve the international dispute. Then another is a reprisal. That is also one of the way to resolve the dispute at international level, but that is also a compulsory means. Generally, the reprisal that are illegal unless they are based upon a previous act contrary to international law. There must be a certain proportion between the offense and the reprisal as a necessary condition for the legitimacy of the latter. So it means that you can use force against another state. If suppose any state that is using force against you, so you can also use the force, but you can use that force in a proportion. There already there is a mention that there must be a certain proportion between the offense and the reprisals. Reprisal are legitimate only when they have been preceded by unsuccessful demand of redress. Reprisal are legitimate only when they have been preceded by unsuccessful demand of redress. Israel action in bombarding certain areas of Lebanon from where the Arab guerrillas operated attack from time to time in different parts of the territory of Israel. No state is entitled to reprisal which may endanger international peace and security. So first way we have discussed about the retortion. You can sever your diplomatic relation with another state. You can impose economic sanction against another state under the retortion. In the reprisal, if any state that is using force against then it means that you can also use the force, but whatever the force you will use against that state, that will be used that force in a proportion. No state is entitled to reprisal which may endanger international peace and security. So you can use only that force through that the international peace and security will not be disturbed. Another is the interventions, as already we have discussed about. Already we have discussed that in that initial stage that a state cannot intervene in the domestic matter of the another state. And it means that one state that will give respect to the territorial integrity and political independence of the another state. But intervention that is permitted only in the case of the self-defense. Means that we can do only interventions in the affairs of the another state in the case of only in the case of the self-defense. Under international law, that is only one of the ground on the basis of which you can interfere in the affairs of the another state. Otherwise, you have no right under the UN Charter, under the international law to interfere in the affairs of the another state. Already we have also discussed about the Article 2, Clause 4, that propounded the principle of non-intervention by state in the following words: all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in a other manner inconsistent with the purpose of the United Nations Charter. The principle of non-intervention of the United Nations find incorporated in Article 2, Clause 7 of the UN Charter. Already we have discussed that you can do interference in the affairs of another state only in the case of the self-defense, and it has been a valid ground of intervention by one state in the affairs of another state for a long time. But as pointed by opinion, the use of force in self-defense can be justified only when it is necessary for self-preservation. So it means that if self-defense, that automatically means that if whatever the force you are using or whatever the intervention you are doing in the affairs of another states, just to protect yourself. Then there is a very famous case relating to that is the Caroline case. In this case, Mr. Webster declared that the necessity of self-defense should be instant, overwhelming, leaving no choice of means and no movement for damage. It means that when you are taking a plea, whatever you have done, whatever the action you have taken in a self-defense, then in that case, you have to prove that whatever you have done in a in a self-defense. Or Mr. West, that the Secretary of the United Nations, United States of America, that have propounded one doctrine, in necessity that is always be instant, overwhelming, leaving no choice of means and no movement for delegation. And what are the facts of that case? That are in Canada, which was at the material time a colony of Britain. Some revolutions were trying to overthrow the government. A ship named Caroline was carrying armed and men from across the river Niagara in America to assist the rebels. These rebels wanted to attack Canada from the side of Niagara. The British government lodged a protest with the American government, but later did not take any action in this connection. Consequently, the British soldier crossed the river, seized the Caroline, and left it floating. When the British government seized the ship, it was within the territory of America. The American government therefore protested and asked the British government to justify its action on the ground of self-preservation. The Secretary to American government, Mr. Webster, propounded a very important principle in this connection. But in this case, as already have discussed that in Canada, which was at the material time a colony of Britain, so some revolutionary that want to overthrow the governments of the Britain or Canada, and that's why one ship that was at that time in the jurisdiction of the USA that was carrying some rebels and some ammunition. And British government have lodged a protest regarding of that to the American government, but on the basis of that, the American government didn't take any action regarding of that. And finally, the British government that entered in the jurisdiction of the USA and finally that seized that ships. But when the USA have asked to the Britain government to justify your action on this principle, then in that case, the Britain that failed to justify their action on this principle. Means that at that time, whatever the principle that have been propounded, at that time there is an instant attack at that time. Just at that time, only some rebels, some ammunition that is just coming to help to the another rebels. It means that there is no instant attack. So on the basis of that principle, Britain was failed to justify their actions. So it means that when you are interfering in the affairs of the another state, when you are interfering in the jurisdiction of another states, so at least you should have some cogent evidence. Whatever you have done in the case of the self-defense. Or your right that will continue unless and until the Security Council interfere. If the Security Council will interfere, then after that you have no right to interfere in the affairs of the another country. Then after that it becomes the duty of the Security Councils to maintain, to take an action against that state who is causing problem who is causing endangers to the international peace and security. Then there is also another way, that is the embargo. This is yet another compulsory means for settlement of international dispute. It is a type of reprisal by embargo. We mean that if a state violate international law or commit international crimes, then the affected state becomes entitled to create obstruction in the transport which are within the territory of the affected state. So if any state that is not following the international law, as you know that every state is doing business with another country, suppose that is not following the international law, any state is not following the international law, so then whatever their ships in your country, you can create an obstruction regarding that. So that is also one of the way to resolve the disputes. Then the Pacific blockade. Generally, we are using the word the Pacific blockade. It means that through this way, if any state that not following the international, then in that case you can block the port of that state. It means that the ingress or egress of the port of that state you can block. It means that neither any ships that can come from that port, neither any ship that can go in that port. So that is also one of the way. But if you are imposing the blockade, then you have to keep in your mind that blockage must be a peaceful. If suppose the blockade is not a peaceful, then it may in that case it may be the international peace and security can be disturbed. It means that the other state can use of force. So that is also way to resolve the dispute. But that the way that is the way you have to use very carefully at international level to resolve the disputes. Already we have discussed that about the United Nations. We have already discussed about the Security Councils, and we have discussed that ultimately that is the duty of the Security Council to maintain international peace and security. In the initial state, we have also discussed that in spite of that, there are so many failures of the United Nations, but that is the big achievement of the United Nations. Yet there is no third world war. It means that that organization that was created in 1945 or yet it means 78 years there is no third world war. But that is it doesn't mean that the Security Council have played a very important role in some cases, whether that is a Palestine problem, Indo-Pak conflicts, you can say Congo, Cyprus and the Arab-Israel conflict in 1973. And Iran and Iraq war, Gulf War, 1991. So there are so many instances where the Security Councils that have played their role to maintain international peace and security. But the Security Council has been able to perform its function properly in cases where the interests of the permanent member were not direct involved. That means the Security Council is an effective body, but that's an effective body in those cases where where the permanent member have no exclusive interest. Only in that case that is an effective body. But where exclusive interest, in that cases the Security Council is failed so many times to take actions. Hello, Manshin, it's over on my side.
Thank you so much, sir. Thank you so much for this insightful presentation. And sir, like the way you were explaining, no, it was very like appreciate. For me, it is very appreciated because it was very calm, and whatever you were trying to explain, we were getting all of that. So thank you so much, sir, for explaining. And
Thanks so much.
And sir, thank you so much for crediting your time as well for us, for all the participants as well. Sir, we've had like good amount of questions from our attendees. So
Yes.
with your permission, can we take them up?
Yes.
Okay. So there's one question from an anonymous attendee, and he wants to know, how can we stop illegal migration in India? Are there any laws for that?
Illegal migration, that is an issue not for our country, that is an issue for every country.
Yes.
Sometimes the question arises because as you already know that the in population in our country, you know that there are so much population in our country.
Yeah.
So that's why at the international levels that is required some laws regarding of that. In such type of the cases, how to resolve such type of problems, because that is not only the problem for India, that is a problem for every country. So that is an international issue that can be resolved only when there is a those who are the powerful state, when those who are the developing state, he will take initiative regarding that. That problem only can resolve by the international cooperation. Otherwise, that problem cannot be resolved.
Sir, are there any laws also for this? Are there any strict laws for this?
And that we have to see, because that is totally a different topic, because international, that is very vast.
Yeah, definitely, sir. I agree with you. So thank you so much for resolving this query. And sir, there's another query, and this is from Radha, and she wants to know, is environmental security and national security related?
The environment security and the national security.
Yeah, are they related to each other? Maybe anywhere, in accordance to the laws or something?
Then the issue relating to the environment, that is first of all, that is a common for every country, environment pollution. Or especially those who are the developing state that are least concerned with these issues. That's why those who are the powerful state, you can say those who are the developed state that are assist through the technology, that are assist financially to those who are the small states. They are helping in their own ways. But about the environment, issue that we can resolve only it doesn't mean that international level there is no mechanism. We are trying at even in the economic and social council, that is economic and social council, that is the fourth organ of the United Nations, that is specifically that have been enacted. Yeah, that is a common platform to dialogue, international dialogue, and there are so many times the issue that have been discussed about the sustainable development. So ma'am, that's the problem that is continue, and the international, those were the international mechanism regarding that is going to be developed, but that will take time regarding that.
Okay, so Radha, I hope you must have got your answer. Sir, we have last but not the least query, of course. So this query is from Rakesh, and he wants to know what can be the threats for any nation in context of security.
That means that every state that want to develop, every state want to those who are the developing state that want to become developed, and those who are the developed state, they want to become more developed. But you just imagine that in this present period, you know about the Ukraine and Russia war.
Yes.
We are not directly involved in that war, but it doesn't mean that the effect of that war that will not be in our country. So indirect, if suppose any country, any two countries or more than two countries that are engaged in any war, indirectly their effects that will be on in our country. Whether we are importing a lot of goods from the Russia, we are importing a lot of goods from the Ukraine also. So automatically that will become costly, and if that becomes the costly, then indirectly that will affect to our life also. Or similarly, and the another about the nuclear weapons. In this present period, the undoubtedly in this war, the Russia have used a lot of destructive weapon against the Ukraine, but till yet the Russia have not used the nuclear weapon. But already have also discussed that who was the president of the General Assembly, that have in their speech that have expressly have stated that in the last 40 years the use of nuclear weapons that was increased, use of nuclear weapons, possibility of the use of nuclear weapons. So maybe if we will not resolve such type of the issues, yeah, we will not take the help of the more peaceful way to resolve the dispute. So maybe in future we cannot stop the third world.
Yeah. It's definitely, sir. I think where we are heading is because of Russia and Ukraine, we will be parted into, I think, parts where US will be favoring Russia, Ukraine, and then Russia will be another favored maybe by the China. And hence we just need some strict laws now and some strict security as well.
And
So
first, what we have required to change in the Security Council.
correct.
We are not able to, the Security Council are not able to take decision because the veto. If any member, whatever the important decision in the Security Council, that is only possible when the all permanent members will give the votes. So those who are the permanent members, generally that suppose in that case, how Russia will give the vote against him, because he is involved in the war. So there are so many times the Russia, even the USA that have used the veto powers, and the Security Council failed to take action to maintain the international peace and security. So first we have required that we will, whatever those who are the member of the United Nations, they will pass a step of the resolution, they will amend the United Nations Charter regarding of this veto power. That's then only that is possible. Those who are violating the international peace and security, so then the Security Council can take action against such type of the states.
Correct, sir. I totally agree that the council actually, the power actually has been compromised,
Yes.
from our countries. Like countries do prefer what they want to do, and hence that power has been compromised. So I totally agree with you.
Yes.
And sir, thank you so much for resolving the queries of our students.
Welcome, ma'am.
And thank you so much, sir, for giving this insightful presentation again. Sir, we were getting a lot of questions in admission processes as well, like how they can take admission. So with your permission, can I show them the site and can I tell them how they can take it?
Yes. May I leave, ma'am?
Yes, sir, no issues, sir.
Okay.
Thank you so much, sir.
much.
Thank you so much for joining in, sir.
Oh.
So students, because we were getting a lot of queries of our admission processes, right? So I will be here to tell you how you can take admission, what you can do, and where you need to go. So simply, you just need to go to this lpu.in. You can see in here lpu.in. Once you click on this lpu.in, you have all the highlights that is either happening or happened or will happen in near future related to the university. So you can explore our site lpu.in, right? So since we're just focusing on admission processes, so you simply click on the admission and you can see all whole lot of segregated programs in here after 12th, graduation, after postgrad, doctoral, 10th, diploma, etc. So we will be taking an example of, let's say, after 12th regular program. So once we click on this regular program, there will be a whole lot of disciplines that are available in LPU is visible to you on the site. You can see engineering, management, law, applied medical science, physiotherapy, planning, design, etc. So since we've talked a lot about law today, so why not take an example of the law? So we will be taking an example of the law, and once we click on the law, that is the discipline, we have the programs that are offered under that discipline. So you can see here BA LLB honors, BBA LLB honors. So here you can actually check it out, what all programs are provided by the university under any discipline, right? So let's take an example of BLLB, sorry, honors. So here you can see whole lot of different options available. So we'll be briefing them in detail right now. So you can see program detail. This is something very important for the student, is because this gives you the eligibility criteria, whether you are eligible for any course or not. So here you can see 60% aggregate marks in your 10+2. English should have been your subject in your 12th grade. And after that, you need to have either LPU NEST test, CUET, or CLET test qualified to be able to get admission in here, right? And after that, we have other conditions as well. You can just check it, what all relaxation, if any case you need, we can provide, right? And after that, highlights. So once you click on highlights, these are the research, student achievements, rankings, etc. Whatever things a student has achieved will all be highlighted in here, and the rankings that university has related to your course is already given on the site. Now the curriculum part is, we provide you curriculum beforehand. Your course is going to be of 5 years, and hence all the topics that you will be taught under that course in the coming years are already given to you in a very segregated and beautiful form. As in autumn term, what all you're going to be learning, and in spring term, what all you're going to be learning, are already segregated for you. So this can actually help you to make a disciplined decision whether you want to pursue a course or not. And after that, you have your fee. This is the most important part for any student, is the fee structure. And you can see that our fee is 1,20,000 per semester. But again, this is not something that our students do pay, because they get a lot of scholarships. And on what basis? On the basis of either 12th or the LPU NEST exam, or different exams as well. So you need to check it out. We have 3 categories, 1, 2, and 3. And hence we have different slabs of scholarships that we provide, 38%, 35, and 30 respectively. Now, either you should have, you can see all the details about if you get a scholarship or not in the categories. Now, what is that marks, or what are those marks that you need to have a certain category of the scholarship, right? So here, if your exam is of 200 marks, you need to have at least 160 or above to get category 1 cutoff, and 150 above from 200 category 2, and respectively for category 3 as well, right? So you can check it here. And for example, you've not got any of these scholarship, don't be sad, we have other scholarships as well. So you can see sorry, you can see that we have scholarships on the basis of CLAT or other special scholarships and financial aid. So you can just check it out in whichever scholarship you fall in, start applying for that scholarship now. Now, this most important part of this webinar, of this admission query resolution, is the last date of the admission. And this is 25th of May. It's not too far, just 10 days from now on. So I would urge to all the students, to all the attendees, start applying for the course, start applying for the test, so that you will be able to get in your favorite course. Now, how you can apply in the test or the course? Simply click on apply now, name, gender, address, state, enter, and then you will be given your dashboard, and then you can just actually apply from there. Or I hope that I have made every query clear of you, how to take admission and where you can go for admission process. For example, you want to have either a call with us, or maybe a video counseling session. So how you can have? Simply just on the site itself, you can schedule a call, you can WhatsApp us, you can have live video counseling session as well. Now, last but not the least is the numbers that we have. You can see, either take a screenshot of it, write it down somewhere. These are all the numbers that we provide. You can basically call on them, and once you call, our esteemed counselors will be here to provide the assistance and hence resolving the queries. So I hope that I have made everything clear as to how you can take part in a particular course in which you want, how you can check whether you're eligible for any course or not, and the scholarship part is also been told. So if you have any queries, you can write in the Q&A box. And now I would, okay, since we're not having any query, so I would ask your permission to take leave. And thank you so much, sir, for joining in. Thank you so much for giving your time, for your knowledge that you've showered upon us. It is really, really appreciative. And thank you so much for the audience as well, for being so much valuable and patient with us. So until next time, stay safe and stay healthy, and meet you soon in the next webinar. And meanwhile, start applying for the course, start applying for the tests on www.lpu.in. So thank you so much for joining in.